All right, I think we're ready to go. Good morning, Council. Welcome to the continuation of the May 10th, 2022 docket of the Kansas Court of Appeals. My name is Amy Klein. All right. I have a tendency to start early, so I think I'll have to restart since now we're getting recorded. Good morning, everybody. Welcome to the continuation of the May 10th, 2022 docket of the Kansas Court of Appeals. My name is Amy Klein, and I'm going to be presiding over today's proceedings. With me, I have distinguished judges J.C. Hurst and Leslie Isherwood. We've got one case that is specially set on today's docket, which is number 123559, the State versus Frank Raymond Crudo. I want to remind counsel that we're familiar with the facts of your case. We've read your briefs. We've read the cases that you cite in your briefs. We've read pre-hearing memos from our research attorneys. And since you've only got 15 minutes, we really hope that you jump right into the argument. Can I get the appearances of counsel, please?
May it please the court, Peter Meharry, Assistant Appellate Defender for Frank Crudo.
Thank you.
And may it please the court, Tony Cruz on behalf of the state of Kansas.
Thank you. Mr. Meharry, did you want to reserve any time for rebuttal?
If I could reserve 3 minutes, Your Honor.
You sure can. And also, because we are streamed on YouTube, if you could maybe give a minute or two overview of the case, just kind of broad brush, so that way if somebody's watching the live stream, then they'll have some kind of an idea of why we're here today. And I won't cut that into your time, but if you don't mind starting out with something like that, then I can, once you're finished, I'll start your time and we can jump right in.
Thank you. May it please the court, again, Peter Meharry for Frank Crudo. This case arose after a traffic stop in 2014 along I-70. Deputies from Geary County Sheriff's Department stopped my client, who was traveling eastbound on I-70 in a pickup towing a camper. The officers testified that they initiated the stop because the license plate on the camper was not properly illuminated. As the officers approached, they smelled marijuana coming from the pickup. They ultimately searched the pickup and then ultimately searched the camper. In the pickup, they did find a small part or a small bit of marijuana. And I guess more importantly for the overall case, they found 19 bags of marijuana in the camper. Originally, a defendant, my client, Mr. Crudo, filed a motion to suppress. That was granted. The state appealed that decision to this court. This court reversed the district court, sent it back down for a new suppression hearing, and ordered that it also be heard before a new judge. With a new judge, the motion to suppress was denied. The case then proceeded to trial. At the first trial, my client was convicted of 1 count of possession and then 1 count of possession with no drug stamp. The jury hung on the more severe possession with intent to distribute charge the state had brought. After a second trial, the jury did convict of possession with intent to distribute, and my client has taken an appeal from that second trial. We've raised several issues on appeal. The first issue deals with the district court's decision to allow one of the officers involved in the stop to testify in specific, we think, details about the drug trade. It's our contention.
Mr. Meharry,
Yes.
could I go ahead and jump you to your third issue
Sure.
with the search of the vehicle and help me understand why the search of that trailer is not the equivalent of just searching the trunk of the vehicle, why we shouldn't just view this as a single unit as the district court did?
We don't believe it should be viewed as a single unit because we think a camper, in this case it was a fifth wheel camper, is markedly different because it's a living space. It's someplace people sleep, they eat, they take it to campgrounds, and they spend time living in the camper. It is not simply a vehicle used to get from A to B. So we think it's that kind of personal nature to the inside that would increase somebody's expectation of privacy with regard to that camper.
Now, don't people live in their cars though? I mean, if we start down the road of the quality of what's going on in the vehicle, doesn't that kind of lead us astray from the whole purpose of automobile exception?
I don't think so, because granted, people unfortunately sometimes do live in their cars, but cars still are predominantly means of transportation. Cars are what people use to get from A to B. That's not what a camper is used for. A camper is used to live in. People take it, they live in it, they go to the great outdoors and whatnot. Its character is, I think, different than a car.
But
And the
does the case law draw the distinction between whether it is moored or rooted at, say, a campground or a lot somewhere, as opposed to when it's being actively transported on the highway? Isn't there a distinction there?
I don't think that should be a distinction, Your Honor. I think that the character of the camper doesn't change. Even if it's at a campground, it's still capable of being moved by a vehicle. But the character and the reasons for having a camper are the same. And that is that you take it to a place, you live in it, you eat in it, you spend time in it, just like you would a house. In that regard, I think just the character of a camper in this case is different than a car, and it should not be viewed as one single unit as the district court did.
Mr. Meharry, can I clarify though? Are you arguing that the camper should be held to a house standard, or are you arguing that there are two perhaps separate car units here?
Well, I'm not arguing there's two separate car units. I'm arguing that they are separate for purposes of searching. And my standard, I think, is that they need probable cause specific to the camper to search it.
But I'm sorry to interrupt. So they would need probable cause for each unit, is your argument, but not that the standards for search of the camper are the same as a home.
I don't think I can argue that the camper is the same as a home.
Okay.
But I do think it does need probable cause for a search. And the officers in this case testified that they had no indication that anything criminal was going on with the camper. They both testified that they walked by the camper, did not smell anything. They both testified when they got up to the pickup, that's when they smelled the marijuana. And that probable cause was very specific to the truck. It was not in any way tied to the camper. So they essentially had no indication, no hunch, no inkling that there would be anything as far as contraband or anything illegal in the camper, but yet they basically did a general search of the camper. They
So,
searched.
Mr. Meharry,
Didn't they find marijuana in the truck?
Yes, they found marijuana in the truck. That's after they smelled marijuana coming from the truck. But again, they didn't smell marijuana coming from the camper and testified they had no indication that anything criminal was going on with the camper. So it was very specific. The probable cause was to the pickup. There was nothing indicating that there was a reason to believe anything was going on with regard to the camper. And that's why I think it is basically just a general search. You have probable cause to the pickup. That shouldn't allow you to, I think, rummage through somebody's camper, which is, we believe, separate and apart from the pickup.
So, Mr. Meharry, I want to go back to the lens that you want us to view this through. So you, in response to Judge Hurst's question, indicated that these are two separate, I don't want to say entities, but sources, if you will. You don't want the residential standard to apply to the camper, but are you saying the automobile exception doesn't apply to the camper? Exactly. If we were to view them as separate and not a single unit as the district court did, then what standard would govern that trailer? If it's not the residential and it's not automobile exception, what are we looking at?
Well, I think what you need is, again, I don't think the case law will support me to argue that this should be viewed as a house, but I think the automobile exception is you still have to have probable cause for that truck. And that in this case, they did because they smelled marijuana. I think that probable cause standard should also apply to the camper. There must be probable cause specific to the camper to allow the search. And that's what we don't have here. Again, not to repeat myself too many times, but the officers testified they had no indication that anything illegal was going on with the trailer.
So,
Probable cause was
sorry.
specific to the pickup. And we believe that they should have, if they want to search it, they should have probable cause specific to the camper.
so then what relevance in your mind does it have that there's some sort of residential quality to the camper? How is that to factor into our analysis from your perspective?
Because the lower standard for a car is because it's used for means of transportation. It's not given, one's house is one's castle, so you're giving more protections. We think the fact that it is used as a living space means that at the very least, you have to have probable cause specific to that space to allow the search. With automobiles, you have probable cause plus readily mobile. And here there was probable cause to the pickup, but you had
Is that
nothing to the
how-
camper.
Is that how motorhomes are viewed? If I were an officer and I just pulled over a motorhome, does the automobile exception not apply because it has a residential quality to it?
Admittedly, the United States Supreme Court has applied the automobile exception to a motorhome, specifically the Carney case that we've cited in our brief. They said that after stopping a motorhome, they were allowed to search the living space within that motorhome. But again, I think that's different because that is one unit. And, if you have probable cause to that vehicle, I think case law is pretty clear, extends to all parts of that vehicle. And that is essentially what Carney said and what case law has said going forward. But I think there's a distinction when you get into a camper that is being towed.
So are you essentially saying, let's do a hypothetical here, that someone was towing a car behind a car? So I'm driving a car and I'm towing a car behind it. You're arguing that if there's probable cause to search the car that's driving and towing the car, that doesn't necessarily attach to the thing being towed. But that thing being towed might also have the automobile exception attached to it.
What the case law has said, and we acknowledge that there's case law that has allowed the search of trailers. But I think there has to be a line when that trailer is, in this case, a camper where somebody spends time living, sleeping, and eating. So I think the case law would say, admittedly, that this doesn't help our argument, but I can't ignore it. The case law says, particularly a couple cases we cited, somebody was pulling a U-Haul and they were allowed to search the U-Haul. But I think it is different when you have a camper. And I think that's why we believe that there should be specific probable cause to the camper before it can be searched under the automobile exception, because there's probable cause to the vehicle towing it.
All right, so you're arguing the automobile exception, you're not arguing that it doesn't necessarily apply, but that we need just separate automobile exception PC for each unit.
I think at the very least, you need probable cause specific to the camper to allow the search of the camper. And here they searched the whole camper based upon what they smelled coming from the pickup. And we don't think that is sufficient to allow that search.
Counsel, did they search the camper before they found their marijuana or after?
It was after, Your Honor.
Okay, that was my understanding, that they didn't go to the camper until they smelled marijuana and also found marijuana, correct?
That is correct.
Can you
It
talk
doesn't-
about what they found? I'm so sorry, Judge Klein.
As far as what they found in the pickup, it was described, basically a very small amount of marijuana was found in the pickup. I think the description was on the center console. It was either described as flakes of marijuana or a bud of marijuana, but a very small amount of marijuana was found in the pickup.
And once they found that marijuana, isn't it true that they could search anywhere in the vehicle based on the presence of marijuana?
This court and Kansas Supreme Court have held that once you find drugs in a car or a vehicle, you are allowed to search every nook and cranny in that vehicle. We recognize that, but again, we're drawing a line with the camper that's being towed by that vehicle. And given that there was no probable cause at all with regard to the camper, we think that's a different cat.
Mr. Meharry, and I don't recall there being any specific testimony in this regard in the record, but I guess I'm asking for a fresh set of eyes. Was there any testimony at this suppression hearing from the officers as to whether they believed or did not believe that the amount of marijuana that they located was sufficient to provide the degree of odor that they had detected?
I don't remember any testimony with regard to, I guess, their views as to whether or not the small amount they found would be consistent with what they smelled. I don't think, I mean, I'd have to double check. There were 2 suppression hearings, but I don't remember any testimony along those lines.
So nothing along the lines of we found this, but it neither confirmed nor dispelled our suspicion, so we proceeded further.
Nothing that I recall, but I do think, they did testify they smelled marijuana in the pickup. They also specifically testified as they walked past the camper, they did not smell marijuana. So it was solely coming from the pickup. But again, I don't recall any testimony as to whether or not the amount they found was in line with what they smelled.
Thank you.
Counsel, your time has expired unless you want to move into your rebuttal time, but I don't want to cut off questions from the panel if we've got any additional questions.
Thank
Okay.
you.
All right, thank you. You may proceed.
Thank you. I believe that the court has pretty much picked up on the arguments on the search. There's a state's opinion that basically, and I think the case law supports it, that the camper and the truck are considered by law one vehicle. And if it's moving, as it was on I-70, then the automobile exception applies to that search. And once you have got probable cause to search the truck, then you have probable cause to search the camper. I believe that the case law is quite clear that unless that camper is actually fixed to a camping site where you have, the sewage line hooked up, the water line hooked up, then at that point, it's considered more of a residence and where you would have to apply for a search warrant. That's not the case here. So I believe that the officers were in fact lawful in searching the vehicle as they did.
Mr. Cruz, I think I don't hear a strong argument from the defense regarding treating this as a residence while it was on the highway. Can you address the necessity for separate probable cause though for each unit? I know you've said you think the case law is clear, but I will say there is conflicting case law on this, so it's perhaps not quite as clear. I do know there's a cite to a case regarding the back of a pickup truck and a camper shell. Do you think that the nature of the camper being towed or an RV, et cetera, knowing that of course many people are treating them as homes now, warrants separate probable cause just for the unit? Even if you applied the automobile exception to the camper, why would there not need to be probable cause? Because it does appear that the officers testified that they really didn't smell marijuana from the camper. So can you address that, why they aren't separate automobiles?
There's a state's opinion that because the fact the camper was in fact attached to the automobile, then it becomes one automobile. It may be a longer one, a bigger one, but it's still one moving vehicle. It's not as if they can be separated. It's not as if the camper can drive off by itself. The fact that it relies on that vehicle or the truck in this case to be towed, that it's one vehicle. And so as long as, when I say that the case law is obvious, or on point, I'm referring mainly to the Carroll doctrine that once you've got probable cause to search a vehicle, you can search anything within that vehicle. given that they're attached, that's the state's argument that it becomes one vehicle. And therefore
Okay.
you don't need separate probable cause, one for the camper, one for the truck.
So you're not arguing that there is specific Kansas case law that says a camper attached to a truck is one vehicle?
I don't believe there is any specific Kansas case law on point. I've cited several cases from other jurisdictions that have applied to the same principle.
Right. And there are cases that do them separately also, right?
Yes, ma'am.
Okay, I just wanted to be clear because you said the case law was clear and I wasn't sure if I missed something in that. Okay, go ahead.
And I believe that the court had a very good argument when you referred to, and for example, if you have an RV that's towing a vehicle, and we see this all the time, that if the officers have probable cause to search the RV, it's the state's argument that it doesn't make any sense that they've got probable cause to search the RV, but not the vehicle being towed, because again, it's one big vehicle. It may be that in a separate compartment, but under the Carroll Doctrine, you're allowed to search every compartment where contraband may be found. So I believe once they're connected and they're in motion, then they would constitute one vehicle. And that'd be like sort of like saying, if you've got these dual tractor trailers where you've got probable cause to search the cab of the trailer, that you would need separate probable cause to search each additional trailer. As long as it's one unit, I think that probable cause extends to all of the containers attached to the main vehicle. And if there's any other questions, I'll be free to.
Is that, no, Mr. Cruz, so is it your contention that, so if this court did think they were separate, do you think the officers had probable cause to search the separate unit?
That would require, actually, Judge, I think that would require the matter to be remanded back to the district court for a third motion to suppress, because basically then the issue would arise at that point. Once the officers found the marijuana in the first car, would the officers have arrested the defendant? And if so, what would have happened to the vehicle? Because obviously the thing's on I-70, you can't leave it on I-70. So at that point, the question would have become, would the vehicle have been searched?
So you think you would have had to go the inevitable discovery route?
Either that or search incident to arrest, possibly. So again, I think because that issue wasn't raised by wasn't addressed during the first two suppression motions, I believe that is something that would have to probably be remanded back to find out what would have happened to that vehicle.
Okay, so the suppression hearing, the state just focused on the PC for the truck, and that because the camper is attached, therefore it attaches. And so I just wanted to be clear that that is the state's argument here.
Yes, Judge.
Okay, thank you.
Counsel, speaking of the two hearings that have already occurred, the testimony at the first hearing in October addressed additional probable cause than what was discussed at the November hearing, correct?
I believe so, Judge.
In October, we have testimony about the conversation the officers had with the passengers about their unusual travel pattern, about, their vague answers with respect to why did they have a camper, where are they staying, where are they even staying in the camper, where their destination, all of those issues. Can you tell me why that testimony from the October hearing wasn't addressed in the November hearing?
I believe I want to say we had some concerns. I can't recall if we tried and there was an objection to hearsay. But I believe there was a reason why, but I can't tell the court specifically why that wasn't addressed. But I believe there may have been an objection to hearsay, and so we just decided not to push that issue.
So there's no incorporation of that prior transcript, which would have been, you had a record of it, the Court of Appeals read it in the
Right.
first Credo case. I couldn't find any incorporation of that prior transcript or that prior testimony in the November hearing. Is that correct? That didn't
That's correct.
happen?
Right, Judge.
Okay. And Judge Sexton, the second judge, in his order specifically said he didn't even look at or consider the testimony from that first hearing. So I wanted to find out if there was some agreement to that respect, or did anybody talk about it? But you're saying no, they're just two standalone hearings.
Right, Judge. And if nobody has any questions, I'll rest my arguments on my brief.
Any other questions? Okay, thank you, counsel. All right, let me get your timer set again. You got your 3 minutes. You may proceed.
Thank you, Your Honor. I don't really have anything to add. The only, I guess, a couple points I would make quickly. One is, it was my understanding as far as the second suppression hearing, it was basically a new suppression hearing with a new judge. So nothing crossed over, and it was just, this court sent it back, ordered it before a new judge, and the judge took it as if he was looking at the case for the first time. Second, as far as the probable cause, I would point the court to it's volume 18, roughly page 36 and 37. And that's where the officer testified. He was asked after he smelled marijuana coming from the pickup, he was asked at that point, you had no evidence to point that there was anything illegal in the trailer, correct? And he testified at that point, no. They didn't have any probable cause for the trailer. And we believe that that should, at the bare minimum, be necessary before allowing a search of the camper in this case. That's why we believe the suppression should have been granted as far as the marijuana found in the camper. And I don't have anything else to add, but would ask this court to reverse, order that evidence suppressed, or for the other reasons we've argued in our brief, remand this for a new trial.
Any other questions? All right. Thank you both. We're going to take this matter under advisement and we'll issue a decision as soon as possible. We do appreciate your arguments today, as well as the excellent briefs that you both provided.
Thank you, Your Honor.